If you are or want to be a street photographer or a street video media journalist such as a vlogger working in public spaces, then here are some key facts about public photography and filming. Photography you need to be familiar with. Just to be clear, while the law is broadly the same throughout the United Kingdom, although it's not exactly the same everywhere, here are some suggestions by taking the law in England and Wales into account. The main key facts about public photography: UK law does not prevent or prohibit you from taking photographs or videos in a public place. There are exceptions, for example certain bylaws which prevent professional photography in places like London's Trafalgar Square and Parliament Square as well as royal parks. Even taking those exceptions into account, you as a member of the public are free to take photographs and videos in any public place, with the obvious being this should not be of an obscene nature. You need to be careful of taking videos or photographs from a public place into a private place. For example, using a zoom lens into somebody's bathroom is going to be a breach of their privacy. There is a presumption of privacy within a public space. There is actually no law for the presumption of privacy for individuals in a public place. However, there are narrow exceptions where is a reasonable expectation of privacy. If there's a specific incident that somebody just cannot avoid, they should have a reasonable expectation of privacy, and they just happen to be in a public place. Really, you need to exercise caution in going along and filming it. This could end up in you breaking the law. There is no requirement to delete the photographs or the videos you have taken. However, someone may object, and they dislike any photographs or videos taken while they are in a public place. A member of public or a police officer can request nor require you to delete any photos or video taken from any device or cloud storage system. No one has a right to view your photographs or videos other than where there is an exception in laws, such as you're being detained for the purposes of a legal search by authorized legal person. No one has the right to require a copy of the photograph or the video save unless you're being detained and material is being seized for the same purpose. Photography in shopping centers: most of these are not publicly owned and are private properties. They can have their own rules and often has prohibitions around photography and videography inside the shopping areas, depending on how you are taking photographs and the videos inside their shopping center, although this may not be a problem. But if you are asked to stop and to leave by security on the owner's behalf, then you must oblige, as the shopping center will become private premise to you. You therefore would become a trespasser if asked to leave and you refuse to leave. They are allowed to use reasonable force to protect the private premises to remove you, but they cannot seize your camera equipment and they cannot search you, nor can they view the material taken. You should bear in mind various parks and libraries and places such as supermarkets and or shops will have their own rules usually restricting photography. Expect to be asked to stop if you're walking around these premises and filming. They may well ask you for your personal details. This is the go-to thing for members of the public. Security guards and police officers may ask you to identify yourself as a photographer and to provide proof of your name, sometimes even details you are a journalist. However, you are not required to provide any of these details unless you are being detained and arrested by the police. Remember, when taking someone's photograph or filming of any person, this could amount to harassment, which is an offense. Even this through is not really simple to prove as harassment. Because legally harassment is defined as follows: a course of conduct on at least two occasions where the person knew or ought to have known it amounted to harassment of the other, and this is set out in Section 1 of the Protection of Harassment Act 1997. The section is of relevance to street photographers is Section 1 paragraph 3c, which provides as follows: this subsection. The definition of harassment does not apply to a course of conduct if the person who pursued it shows that in the circumstances the pursuit of the course of conduct was reasonable. Given the average case of a street photographer, vlogger, filmmaker in a public place taking photographs or filming provided IA in such a way this is being done is reasonably and therefore legally can't amount to harassment. Due to this, there's a specific defense available in the Act: wasn't a course of conduct on at least two occasions, both of which were shown not to be reasonable and not done with the intention where the person knew or ought to have known that this was going to amount to harassment of the other person. A case made out for harassment. This is not the same throughout the United Kingdom. In England, Wales and Northern Ireland, harassment is a criminal offence which attracts up to 6 months in prison, fine, or both. However, In Scotland, harassment is not a criminal offence. A person would need to apply for a non-harassment order, and a person would have to be in breach of the order, and then this would amount to an offence. The Anti-Terrorism Act 2000 with respect to the filming of police stations and buildings of national importance could amount to an offence if there was intent is to publish or communicate any information about members of the armed forces, intelligence services or police. If such information is of the nature designed to provide practical assistance to any person committing or preparing an act of terrorism. This being said, it could be unlawful to use Section 58A for a police officer to arrest someone photographing or filming police officers in their ordinary policing duties without some real grounds for suspecting the photographs or film are being taken to aid to a terrorist as fact. Something which you could unwitting find yourself in breach of is the General Data Protection Regulations (GDPR) by publishing photographs or video on social media platforms, but there's an exception in GDPR, what is called the household exception. If something is entirely for personal or household use, this is exempt under GDPR. However, only in 2020 a grandmother was ordered to remove photographs of children from Facebook or else face a fine. Looking at GDPR from a photographer's perspective, there are what is known as special purposes for which there are exemptions under Article 85 Section 2 for the reasons of the freedom of expression and information. These special purposes are set out as follows. This could be for the purposes of journalism, academic, artistic and literary purposes. You do have to give special attention to what photographs, videos you're using or what the circumstances you are using them for, how and why you are using them. If they are for one of the purposes which comes under one of these special purposes, then it's more than likely going to fall under freedom of expression and/or information. This could be a continuing debate around who can photograph and/or film what, when, well, why and how, but ultimately the scenarios where photography and filming is going to be outright wrong should be fairly obvious, and in the vast majority of photography and videography is in public places, therefore should not fall foul of GDPR. But as always, if you're going to photograph or film someone or something in a public place, there is always a possibility of this getting you into situations which can become questionable under current law within the UK. It is highly recommended you should seek proper legal advice first, so you'll feel safer given you've had a professional view on public photography and/or filming within the UK.